Now, 2 more people have been arrested for alleged incitement of violence during last month's civil unrest in Gauteng, as well as KwaZulu-Natal. A number of the alleged instigators were linked to the riots through the use of their social media accounts. So the question we asked this afternoon is, how can incitement through social media be proven? I'm joined now by social media law expert Diana Schwartz. Ms. Schwartz, a very good afternoon to you, and thank you for your time. Perhaps let's start first with the laws that govern social media usage in South Africa, and whether those laws are actually global in nature and not just perhaps limited to certain territories.
Hi, good afternoon. It's lovely to be on the show. I think let's start off by saying that the common misconception around social media and the laws that apply to the online space is that there's some type of separate body of laws, and that's not the case. The body of laws that we have in South Africa and likewise globally will also apply to the online space. And there are very similar laws that we have in South Africa that we have globally as well in regard to social media, and then there are particular pieces of legislation that are promulgated to directly impact social media offences.
So let's take a look at the cases that we're facing now in South Africa. Quite a number of people who have been allegedly linked to the riots that we saw in parts of Gauteng and parts of KwaZulu-Natal in July. One is supposed to appear in court today, at least a couple, but one that we are speaking about now specifically is using the Twitter handle Spitipiti Evaluator. Let's take a look at the tweet in question here, the tweet which was part of the allegations that are meted out against a Spitipiti Evaluator. It says, okay, here, 10 questions about the unlawful jailing of President Zuma, and the biggest error in law by the ConCourt. One is, why didn't the ConCourt give directives to Zuma's legal team? All right, we seem to have lost that one. But basically, here are some of them that Spitipiti Evaluator speaks of. I want to ask you here, Diane, where does the issue of freedom of expression fit in here? In the sense that here's an individual who is airing their views and airing their thoughts. How are those a contravention, and how does one factor freedom of expression into the existing rules?
So freedom of expression is obviously one of our constitutional rights. And so freedom of expression is a right that needs to be balanced and weighed up against other rights. So we have a limitation clause in our Constitution, Section 35, which is a limitation clause and requires these rights to be balanced against each other. So what we often have with social media is we have to weigh up the rights. So the right to freedom of expression will not trump upon another's right to dignity, another's right to privacy, and therefore incitement to violence as well. If you weigh those two up, it cannot, your right to freedom of expression when inciting violence cannot trump upon someone else's right to protection in terms of the law.
So let's take a look at some of the laws that Twitter does view as prohibitive. For example, one of them is terrorism and violent extremism. This is part of the Twitter rules there. They say you may not threaten or promote terrorism or violent extremism. That's one of them. Another one is violence. You may not threaten violence against an individual or a group of people. But they also talk around issues of abuse or harassment. You may not engage in the targeted harassment of someone or incite other people to do so. In the instance of harassing a particular individual or inciting others to harass an individual, what do you make of the current existing cancel culture, for example, that seems to exist? If somebody, perhaps a public figure who is known, does something that a fan or somebody on Twitter does not approve of, and they then go out on a campaign to expose what they believe this particular individual who is known has done, and also then goes on to focus on the means and the livelihoods of these particular individuals, calling for them to lose their jobs, for example, for them to be sacked. How does Twitter view that?
So I think it's a very complex issue, but there are laws that prohibit this kind of conduct on social media. And what we need to remember about Twitter and the big tech and the social media platforms is their rules or their T's and C's is a legal binding contract that we agree to. So when we sign accept or we tick accept on a particular platform in order to gain access to the platform, we are agreeing to those terms and conditions, which is actually a legally binding contract. And then on the other hand, we have particular laws, like in South Africa, we've got a particular law, it's Section 17 of the Riotous Assemblies Act, which states that a person can be found guilty of incitement to violence when several elements are proved. And one of those elements are words published by the person. And publishing something is the same as posting it on social media platforms, because social media platforms are in fact public platforms. So the victim in these cases would then be able to press charges. It's a criminal offence. Section 17 prohibits incitement to cause violence. And then we also have the criminal offence of crimen injuria, which is the unlawful and intentional impairment of a person's dignity. And that's a criminal charge as well in respect to hate speech or cyberbullying or cyberstalking. And of course, there's also cyberbullying as well that happens and is rife on social media platforms. And again, there are definitely actions that a victim can take against basically the accused or those who would put those posts out there. So it's very important for the public to be aware of the consequences of what they are posting on social media.
I want to find out from you how this is potentially going to affect people's usage of social media, what it is that they are allowed to say and what it is that they're not allowed to say. Twitter itself says that they are there for people to express themselves. Is this not a platform where people can do that freely?
Certainly, but again, we have limitations. So if we're going to post our opinion, and my opinion is, for example, a racism or a racist slur, and that's my opinion, and I'm posting it, that is going to impair somebody else's dignity, and that is actually going to be a breach of the laws that we find not only in South Africa, but all over the world. And therefore, that right to freedom of expression of my opinion is then limited and prohibited, because it will then encroach upon another's right to dignity and another's right to protection in terms of the law. So it's a weighing exercise that we do. Unfortunately, freedom of expression is not absolute, and we cannot say and do what we like on social media, as it is the public platform, and it has to be in accordance with the laws that we have in each particular country.
In a court of law, how does one go about proving incitement on social media? And one would assume that intention here is important. If the person who wrote the tweet says, I was merely expressing my own opinion, I wasn't necessarily saying that people must go out and do this, I was merely saying what I would do, is that an admissible argument?
So it's quite interesting, because with this particular offence, in regard to incitement of public violence on social media platforms, the courts have actually ruled in a case in 2016, it's Hotz and others versus the University of Cape Town, that intention is not necessarily considered, and normally that would be the case. In any other offences, our courts always look at the intention of the parties and what was the intention behind an action, and they will weigh up each case on its merits. However, when it comes to incitement of public violence, there is actually a case that has been ruled where intention may not be actually weighed upon, as this has actually caused others to commit violence. So that's quite interesting in terms of this particular offence. However, in others, whether it be cyberstalking or bullying, those kind of offences, the court would look at the intention of the parties behind those posts. But again, we must remember that something that we think is in the public interest is not necessarily in the public interest in our views, and therefore would not be an offence. So if we're going to post identities of people if we're going to name and shame on social media, there are legal consequences that can be taken against us.
Do you know, Diane, which are the specific posts by PTPT Evaluator that have been highlighted and flagged as incitement of violence?
I do not know offhand, but it would be obviously those that would incite, violence. Anything that states that, or has the interpretation to go out and harm a particular individual. Any connotations in that respect would be considered posts that would incite public violence.
Diane, thank you very much for your time. But perhaps before I let you go, very, very quickly, would Twitter be involved in the tracking of these individuals, or is this something in the domain of the police?
Definitely. So we would have to obviously, work with law enforcement, would have to work with the social media platforms in actually tracking down these individuals. In South Africa, we have a particular piece of legislation called the Protection from Harassment Act of 2011. And in that particular act, if we wouldn't get the corporation of a social media platform, the court can actually order that the platform make available certain details, ISP details, etc., to track anonymous individuals as well, because we have a lot of fake profiles and anonymous users that it is difficult to track. So yes, the answer is they would have to work together with law enforcement in order to track the proper and correct individuals.
Diane, thank you very much for your insight this afternoon. Very much appreciated. That's Ms. Diane Schwartz, a social media law expert.